Dear professors, dear PhD students, dear colleagues, dear ladies and gentlemen, thank you very much for this organization, for this conference, and also I would like to thank the Central European Professors Network, the Central European Academy, the University Ferenc Mádl Institute in Miskolc, also the Institute in Warsaw, the Institute of, sorry, but I'm so excited, that Institute of Justice in Warsaw. Today, my topic, I was thinking what to present and what to write about that can be maybe a little bit close to the today's generations, and also the parents, the grandmothers, the aunts, but mostly the today's children. Therefore, the topic of my today's presentation is protection of the child's privacy in Croatia, the criminal law perspective, but as I saw, I haven't spoken to this microphone, but as I saw from the program, my topic is going to be overlapping with David's, so the sharing thing problem. Therefore, I will try to focus my presentation on Croatia mostly. What to start and what to say about this topic? A lot. First, I would like to show you the structure, then some pictures, and then briefly introduce you to the provisions and regulation, some European Court on Human Rights, case law. Afterwards, I would like to say something about the regulation in Croatia from the aspect of privacy protection of child or child privacy protection, and something to conclude with, what it would not be definitely, but more than, it would be more in the form of questions, because usually when we are researching, we can conclude something about that, but always rise some new questions about that topic. Therefore, those are some pictures which are posted on some social networks as Facebook, Instagram. Those pictures, you see, I was trying to protect everything, do as GDPR says and states. Those pictures are published by one very famous influencer or very famous public figure in the world. And those are the pictures, her with her children. It looks kind of innocent, right? Everything, we do it all day. Most people do. That's something from the world. This slide shows us the pictures from celebrities in Croatia. At the left is our famous female singer, and with her son, and there is a lots of pictures of her son. And at the right side, you can see this is the picture of one famous singer in Croatia, male singer with his family and his son. And at the bottom, you can see the picture of one very famous handball player, Croatian representative. And with the picture is with his family, of course. Everything seems so innocent, right? But from these pictures, we can learn a lot. We can see the growing up of this little guy. He was famous before he even noticed that, and he was aware of it. He was famous while he was a baby. He was infant. Now he's almost 2 years old, and we know everything about him. He's also one figure of this pop singer. She also has her cosmetics for the babies and his protected face of this cosmetic line. Therefore, we can also see the male singer and his family, and we also can follow the growing up of his son. Nonetheless, we have to say that by this we also can follow their movements, where they are, what they do. So everything what you think it's innocent, you give or they give a lot of data to maybe someone who would like to perpetrate criminal offense. That's one issue. But this is something what I wanted to present you and focus on two main things, not only criminal offenses, but two main things. Violation of the privacy rights of the child. Who are the most often violators? First big issue is violation by media and press. Second is violation of the privacy of the child by their parents. And this is called sharenting. That's something what David will be maybe more precise regarding this issue. This is sharenting. But what also happens, if you think these two topics are not connected, they are. You see, public figures or maybe parents, not public figures, normal persons, publish or post their photos on Instagram, Facebook, or any other social network, and then media take over those pictures and publish it. So we have two violations, from the parents and from the media. So those two issues, although seems not connected, they can be connected. These are the regulations. Why I'm showing you this? Because we are all doing something, and of course we don't want to look at all the legal regulations. It's quite boring. Therefore, here is I won't be reading and going through all these regulations. Everything is in the article. But at the right side, these are the regulations, the general regulations or regulations which are protecting, in general, privacy. And of course, they are applicable to the protection of the privacy of the child. At the right side is specific regulation dealing with the privacy protection of the children. Mostly it's and these are the old documents, and this is the soft law documents. We have two, the Geneva Declaration and Declaration of the Rights of the Child from 1959. But there is also one mandatory, which you all know and you are all introduced to, the mandatory regulation, the Convention on the Rights of the Child from 1989, and this would be our main document for dealing with this subject. These are all the regulations. I want to say that there is a lot of regulations dealing with this privacy, child privacy protection. Especially, you see in Universal Declaration, there is the right to education, the choice, it is in Article 26. There is also covenants on civil and political rights. The protection of privacy is regulated in Article 17, but also in many others regarding children. Then we have the conventions of the rights of the child. And the main issue here, the main thing is the best interest of the child. And while I'm saying this, I would like you to think through all those regulations and try to implement or try to think about those pictures. You saw the pictures before. The best interest of the child. What is the best interest of the child? Article 16, yes, it says that every child has the right to privacy, has the right for legal protection against interference with his privacy, family, home, correspondence, etc. Article 12 has a very interesting provision, because it says that the child has the right to express his view freely in line with his or her age and maturity in all matters affecting him or her. We have some other legal documents like the EU Charter, and yes, these are all the aspects of privacy, the views of privacy that EU Charter protects, and it protects it for children as well, or for the child. And there is also one interesting provision regarding today's topic, and today's topic about posting violation of privacy of children, mostly by photographs, mostly by posting, mostly by sharing, and of course media, publications in media. And you have here Article 24, which says you can say most identical as to Article 12, that child has the right to protect his privacy and also has the right to care which is necessary. The parents has to bear this in mind. And the child has the right to express their views freely, which shall be taken into consideration on matters which concern them in accordance with their age and maturity. Also, almost the same provision as in Article 12 of the Convention on the Rights of the Child. Then we have GDPR. Why GDPR? GDPR, of course, it actually regulates the age of the consent for processing of data. And it is regulated in Article 8. And the processing of data by GDPR is at a level of 13 years. You are all acquainted with this fact. But regarding in Croatia, our implementation GDPR Act, actually the legal limit is 16 years. Therefore, only persons with the 16 years can give the consent of processing data to Facebook, Instagram, or etc. So they cannot have their own profiles before 16 years. There is also one interesting provision in Article 6, which actually GDPR says that the controller must bear in mind the best interest of the child. What does it mean? It means if the controller sees that the best interest of a child overrides the legitimate interest, you know that you all have to click legitimate interest, yes, agree or not agree, when you are approaching to some application on the internet or some other social network or something else, then the controller must pursue in that interest, the best interest of the child. But what is the problem here? The best interest is not defined. The best interest of the child has to be determined in each case individually. So that's the problem, because we have a big discretion of the controller or any other person who is dealing with the best interest of the child, including us, the parents, including the grandmothers, and then maybe one day a court also. So we have some directives. This is also something that I want to show you how the child privacy is protected. We have directive which for the accused or suspected minors that have been or they are suspected to be committed criminal offenses. There is also protection of their privacy regarding criminal proceedings because it has to be in absence of the public. Regarding that case, that was a very interesting topic that Latvia actually stated. When one minor has done some accident, he caused some accident, and what was the issue? The issue was, do the authorities or the police can give the personal data of the minor to other authorities or to private persons for criminal proceedings or for tort proceedings? And the Court of the European Union, the Curia, decided that they have and they should give the personal data of the minor. Nevertheless, it's a minor, but the person under the age of 18, they have to give the personal data to the others in the goal of prosecuting for criminal proceeding or for the tort proceedings. This case is Rigas-Satiksme. I don't know if I have pronounced it correctly, but I think I have. Then we have the European Court of Human Rights case law, which is also dealing with the privacy protection, especially the protection of the child privacy. And there is a lot of, I have done it, there is a lot of cases in my paper, but here are only the most important one. The case von Hannover versus Germany. Actually, why this is very interesting, it is kind of a key case, but it's interesting because it states how photograph is very important and which personal information can contain. Therefore, photograph is one of the most, let's say, most protected or most important for the privacy protection, because it contains a lot of private information. You can conclude, as I said before in the introduction, a lot of things from the photograph, right? You can see the color of the hair, how the little boy looks like. You can see where he is at the moment. You can follow the movement of this little girl, the growing. You can conclude a lot of things from the photo. Therefore, in the case of Hanover versus Germany, also is stated how photography is important, because it may contain very personal or very intimate information of the person or his family, and the person's image constitute one of the chief attributes, the main things of his or her personality. Then again, in case Rodina versus Latvia, it's said that even a neutral photo, you remember from the introduction, even a neutral photo, if it's accompanied by a story that portrays the individual in a negative light or in any other light, can be or can constitute a serious intrusion or violation into their private life or into their privacy. We had very interesting case in Croatia regarding child. It's called N.Ash versus Croatia. And why is this a very important case? Because actually what court concluded in that case, that you see, always you have to waived the public the right to public information and the child privacy protection. And in some cases, this public information can override the privacy protection of the child. And in this case, that was exactly the thing. What happened? It was one very long custody case, and our social service gave the custody to the young, I don't know, it was boy or girl, young child. She or he was an infant at the time. The custody to her uncle. And her uncle from the father's side. And then the grandmother from the mother's side, she disputed that, and she wanted also the custody. She lost in all instances. And what then happened, she showed on TV. And when she showed on TV, in this program, in this public, it was one story, one reporter, and they show everything about this child. They show documents, they show the name, they show not the picture, but the name, the address, everything. And then this uncle sued her and criminally charged her, not for the criminal offense that I will be presenting in a few minutes, but for the breach of confidentiality of procedure, because custody procedure is secret. And what happened? She was charged and convicted for criminal offense. And all she wanted to do is to show the public that there is no criteria, there is a big discretion in custody proceedings. What the European Court concluded, and she then she lodged a complaint to the European Court of Human Rights, and because she said that her freedom of expression was exposed here and was violated. Why? Because lots of other people made the child's identity public before she did in this TV program. And the court stated, yes, there is your violation of Article 10. Then, in this case, Article 10 prevailed over Article 8, or privacy protection of the child, believe it or not. There is one other case from Bogomolova versus Russia, very interesting. Article 8, it was violation of Article 8. What happened? It actually happened that the picture of a young boy was published on the cover page of a booklet entitled "Children Need a Family," published by Center Psychological, Medical and Social Support. And how this picture got there? Mother, so be careful. Mother and son were traveling in one tourist group, and the person who was traveling with them, one man, took a picture of the boy. And she gave a consent, of course you can take a picture, but she didn't know the main purpose, what would be used for. And what would the purpose was? To put it on a cover of this booklet. And she didn't give consent for that. And what happened then? People tried to, they start to call her. They ask her what happened, why she lose custody, what's wrong with her, where is her child? And she got in very embarrassed situations, even so that the school asked what happened. They were trying, and then they investigate the family, the social services investigate the family, but nothing happens. It was a little picture that showed on a booklet. And then, because of all these circumstances, the European Court of Human Rights said, yes, this is violation of Article 8. Regulation of privacy and protection in Croatia, this is of big importance for today's topic. We don't have the privacy, we don't have the definition of privacy, but we do protect it through constitutional provisions, also through lots of other provisions of lots of other laws, let's say like the Media Act, the Electronic Media Act, the Electronic Communications Act, there is a new one from this year, the Consumer Protection Act, the Family Act. Then we have also the Youth Courts Act, which is very child-friendly, and of course, ultima ratio with a penal code. We have a protection. We have the protection of privacy. It is a special chapter and is of course applicable to all children. But we have also one special criminal offense, and this is violation of privacy of the child. And why I'm saying this, because I would like to read you, I know it's always boring to read something, but I would like to read you just to see that everyone can be criminally charged and convicted for this criminal offense. So criminal prosecution can be instituted against a person who disclose or transmit something, anything, from the child's personal or family life, publish a child photograph, or reveal the child's identity, contrary to regulations, to you see all these regulations, to the GDPR and other regulations regulating the privacy protection of child, which caused, but we have to have a consequence for criminal offense, which caused the child anxiety, ridicule of peers or other person, or otherwise endanger the child's welfare. So we have to have the consequence. Therefore, what can we conclude? You see, this is the statistic for this criminal offense. It was only 10 criminal offenses. There were only 10 criminal offenses in the period, in 6-year period, in period from 2016 to 2021. I have not been doing the case study of each subject. Therefore, I cannot say if one of the perpetrators was maybe the parent or grandmother. But what we can say, what we can say from the report of the child's ombudsman, that there are lots of cases of privacy, of violation of privacy of the child. They had in 2021 83 reports, and believe it or not, it happens from all persons, all legal and all physical persons, even by social welfare institutions, hospital, kindergartens, schools. They're all violating the children's right. But what is most and worrisome, what is the most problematic and worrisome is the violation by the family members or close related persons. Believe it or not, violation was made also during some local campaigns and elections for purpose of achieving the political goals. Yes, minute. I am. I'm in the end. So, to conclude, and as I said, there is more questions than answers. Is the regulation good in Croatia? We can say regarding media and press, yes, the regulation is good. Implementation, lacks. But that's, I think, in all countries. The more problematic is this specific protection of child's privacy from their parents. So we can say that actually the child privacy is protected very well, but not from their parents. Of course, there is our legal obligation to monitor our children, but in how deep do we have to, or we have the right to go into, especially if our children ask us not to post some photo and they don't want to be on that picture, and please mom, don't put that on Facebook, and we do it. In my paper there was some researches that in most cases parents didn't listen to their children. So, of course, there is a question, or a big question, what would be the age on the consent of the child? How old he has to be to say, mother, please don't do it, don't put the picture. 8, 9, 13, or maybe 16, I think that's debatable. And for all of you, I would conclude not to something definitely, but please think of what you are doing, what are you posting, nephews, sister, brothers, etc. Thank you very much. I'm sorry if I prolong, but I will just a little bit abuse my time. And I would like to thank you everyone. I would like to thank Professor Vielec for having us in this, of course, and Professor Ede Szilágyi, but Professor Vielec for having this group that I have to say I feel like home. It was so warm. I made some, not colleagues, but I can say friends, David, Dusan, Katarina. I have met some people that I really like, and I had the opportunity to meet him as Katarzyna, and I would like all of you for technical support as Barbara, Sylvia, and etc. Therefore, I'm done, and I won't be speaking anymore. I won't even debating anymore. So thank you very much for listening.